Hey everybody, estate planning attorney Paul Rabelais here. Got an action-packed live stream again this evening. How to leave your estate to your spouse. So this is a good one. At least in my view, it's a good one. Any married person or any person who might get married in the future really needs to pay attention to this live stream. With a lot of decisions that married people make, they have long-lasting impact. So we'll be going through all those decisions, the pros, the cons, the what to think about. In fact, I'll break this live stream down into 4 parts. 1, why this decision is so important. 2, what are your options if you're married on how to leave your estate to your spouse? Number 3, what are the tax consequences to the various options that you have in leaving things from one spouse to another? And then 4, we'll go through some unique or special circumstances that married couples face when they create their estate plan under certain circumstances. All right, so we've got the chat. Here's the ground rules. We've got the live chat. That's why I do the live stream, is to be able to engage in the live chat. So you can talk amongst yourselves. I really don't look at the live chat until I finish my presentation, and then we go through them one by one, and I go through them fairly quickly. So if you have a question, feel free to be as clear as you can be with your question or a comment or experience. Same thing. Gotta say hello to my favorite YouTube live stream people. We got Larry on the call from California, and we got Ann with her hands waving emojis. It makes me laugh every time I think of that and every time I see that. And Jalen as well. So good to have you here, and let's get rolling. Okay, so this how to leave your estate to your spouse, why this decision is so important. In my view, it's at least it's one of the most important decisions married people make as far as estate planning goes. And I could make an argument that it is the most important decision that a married person makes when a married couple or a married person is setting up their estate plan. Yeah, the typical scenario for a married couple, they go through this together. I had multiple meetings with multiple married couples today on the Zoom calls. And so that's just typical. Sometimes you'll see, one spouse do their estate planning on their own by themselves, maybe because they have children from a prior marriage or relationship. Maybe they have the prenup and everything separate. But more than 9 times out of 10, the married couple goes through the estate planning process together, as well they should. All right, so it's important, this decision on how you leave things to your spouse, because not only does it affect your spouse, but it also affects your children. And really, when I say your children throughout the live stream here, I'm really referring to those people who you would want to inherit from you after you and your spouse pass away. For many people, it's their children, but it could be unrelated people or other relatives or grandchildren. So I'm just going to lump that into children. Sometimes I'll say heirs or beneficiaries, but there's nothing here, that I'm going to say that is really just for children. But typically, married people want to leave things to their children. Could affect your grandchildren, this decision, and not only could it have a financial impact on your children and your grandchildren, but the way you leave things to your spouse, quite frankly, and often does, affect the relationships that a surviving parent has with their children, a surviving parent has with their stepchildren, and so or the relationships that the children have with each other. So all that is impacted, believe it or not, by this how am I going to leave things to my spouse decision. All right, so my plan here is really to speak in layman's terms. Most lawyers, because I guess it's what they know, they talk in terms that the ordinary consumer doesn't understand when they talk about the AB trust, the ABC trust, the Q-tip trust, the Cupert, the CRUT, the CRAT. I want the power of appointment. I want to leave all that legal mumbo jumbo out of this live stream, and I don't want to say dumb it down because you're all very intelligent out there, but break it down and make it to where the old 8th grader could understand what we're talking about. So. All right. So that's why this decision is so important. Number 2 is, and it's the big part of this live stream, what are your options? So I'll be talking throughout this live stream about a married couple, Fred and Wilma. Quite frankly, if you're around my age, I'm 58, you remember the Flintstones, and I always kind of try to tell stories to make points. There's a lot of sayings, and a lot of public speaking is telling stories. So we're going to talk about Fred and Wilma. And so they're getting their estate plan together, and they're trying to figure out how they want to leave everything. And you know what? You think a married couple would say, well, why are there even decisions involved? Shouldn't it be just if one of us dies, it all goes to the survivor of us, and after we both die, it goes to our two kids? So maybe, but that decision has lots of consequences down the road. So I'm going to go over the three different options, really kind of 2.5 options. The third one is not as common as the first two. So there's three ways a married person can leave their estate, can leave assets, kind of to or for their spouse. Let's jump right in. The first way married people can leave assets to their spouse, and keep in mind, all of these different ways that I talk about, they have tax consequences as well. When I get to part 3 of this live stream, I'll hit the tax consequences. But in this part 2 of our live stream, I'm going to focus on the non-tax consequences of the decision of how you leave things to your spouse. All right, so option number 1 is, I'm going to call it leaving your estate outright to your spouse. Let's say Fred and Wilma have, between the two of them, an estate worth $4 million. It could be $400,000. It could be $40 million. I picked the number $4 million, and let's say one half of it's owned by Fred and one half of it's owned by Wilma. So Fred has $2 million and Wilma has $2 million. And they're trying to figure out how to leave things to each other. They hear all of the options, and Fred says, you know what? I'm just going to leave everything to Wilma. And then when wills are prepared, there's a saying for this kind of will. It's called an I love you will. And so Fred writes his I love you will, which is a will that basically says, if I die before Wilma, I leave everything I own to Wilma. And so that sounds normal. That sounds great. Sounds traditional. Sounds like perhaps the way it should be among married couples. Married couples built all of this together, and you would think that if one of them died, the survivor says, well, I should own everything because we built all of this together, and who else should own it? So, you got a point there. But you have to look at kind of the big picture. And really, again, Fred and Wilma, they can do all of this either through their will. Fred's will says, I leave my estate when I die to Wilma, or they can do it through their living trust. And the terminology could be several different ways, but essentially when Fred dies, if they're doing this through their living trust, the trust instruments are going to say when Fred dies, then Fred's part, Wilma has complete control over it. She can revoke it. She can change it. She can do whatever she wants to with it. There's no restrictions on Wilma. So it's just like ownership to the spouse. Now, that all sounds fine and dandy, and that's what a lot of surviving spouses certainly want to see. Oh, my spouse just died, but my spouse left everything to me. And that's what he should have done. And that gives the surviving spouse control over everything. But does it give them too much control? Because if Fred leaves everything to Wilma, in Fred's mind, Fred loves Wilma. They had 2 children, Bam Bam. I can't remember the name of the other one. If they're in the chat, y'all can tell me. And he's got his buddy Barney, and Fred's in his mind saying, look, Wilma and I, we've been married for 30 years. And so great marriage, fortunate to be married to Wilma. If I pass away, I'm just going to leave everything to Wilma. And that's how Fred feels. Nothing, who can argue with that? So, but quite frankly, bluntly speaking, and when I talk to married couples, I kind of have to ask them, do you want the blunt version or do you want the sugar-coated version? They all say we want the blunt version. I'd like to know, you YouTube live streamers, do y'all want the blunt version or do you want the sugar-coated version? Throw it in the chat and let us know. But quite frankly, the blunt version is when Fred dies, Fred and Wilma have $4 million. Wilma has $2 million. Fred has $2 million. And when Fred dies and he had made the decision to leave his $2 million to Wilma, now she owns the entire $4 million. And there's some things that can and do go wrong when the surviving spouse is put in ownership not only of their half of it, but also of the deceased spouse's portion or the deceased spouse's half of everything. Because Fred died leaving his 2 million to Wilma. Wilma has her 2 million. She now has Fred's 2 million. She owns the whole $4 million. What possibly could go wrong? Well, maybe Wilma meets somebody and gets married to somebody, and maybe that somebody that Wilma marries has a little kind of nudges Wilma. Hey, don't you love me? Maybe if you die before me, the new husband says, shouldn't we set things up to leave things to each other? Just like Fred, when he died, he left everything to you. Well, Wilma, now we're married. If you die, shouldn't you leave everything to me? And so a lot of things can happen after the first spouse dies. Wilma could be influenced. She could be influenced by a new significant other. She could be influenced by, who knows who she could be influenced by. Maybe one of her children may put influence on Wilma and to, hey, Mom, I've been taking care of you for the last 5 years after Dad died. Dad left everything to you. Don't you think, Mom, since I've been taking care of you for 5 years, you ought to leave it all to me when you die, or maybe just leave my brother a little token? And so there's a number of things where Wilma can intentionally, maybe she falls head over heels in love, or she unintentionally makes a mistake, signs something she shouldn't have, got influenced by someone into doing something that really in the big picture she should not have done. So that's and then when that happens, when Wilma later dies, well, Fred's 2 children, they're out in the cold. So they get nothing. And so that's the downside of when the first spouse dies, leaving everything to the surviving spouse. The risk is that the children, heirs, beneficiaries of the first spouse to die, or at least the people that the first spouse to die would want to inherit after both spouses die, they get nothing. So and look, if I thought this was just a remote possibility, I wouldn't spend much time on it, but it's much more than a remote possibility. So haven't done this for 30 years. You can't imagine. I've had the conversation 100 times where they're like, Mr. Rabelais, Mom died and Mom just left everything to Dad. And we thought that was fine because we knew Dad would leave everything to us when we passed away. Not that we wanted or we needed, but you'd think that Dad would leave it to us, but Dad got married again. And now apparently Dad has changed everything and he's leaving everything to his next wife. And so the next wife's going to wind up leaving it to her kids. Mom and Dad's kids are going to wind up with nothing. So happens very often. And that's the downside of leaving everything outright to your spouse. I know you want to provide for your spouse. I know you want your spouse to have it more than anything, but just realize that circumstances can and do change after the first spouse dies. And that could really mess the overall plan up. I will say there's nothing wrong with a married couple, because I've had this told to me thousands of times. Maybe the husband and wife will be talking to me and the husband will say, well, look, you know what? We've been through this for 25 or 30 years. I'm just going to leave everything to my wife. I know my wife's going to do the right thing. And in many cases, she does. She winds up, leaving it to the children. And who can argue with that as long as it's an informed decision? So that's option number one, leaving things outright to the spouse. Yes, in many cases, it does wind up going to the children of the 2 spouses after the surviving spouse passes away. But there is that possibility that over time, because money changes people and money does funny things to funny people, and then when you get wills and trusts and all that involved and new marriages, things happen. So just now you're aware. Now we go to your option number 2. Option 1, all to spouse. Option number 2 is you're thinking in the back of your mind, yeah, I realize I have option number 1. Sounds simple. I just leave everything to my spouse. But I also know, Fred's saying, Wilma, she's a real looker. She's very attractive. And Fred's saying, if I pass away, I know, those guys down at the quarry, they're going to be approaching Wilma because Wilma is a real catch. And so Fred's saying, boy, I really want to protect my children. So so here comes option number two. Option number two is you leave things. Fred, for example, he wants more protection for his two children when Wilma later passes away. So he leaves things, what I'll call, in trust for Wilma. So Fred says to himself something like this after he gets informed. Fred says, you know what? I realize I could leave everything to Wilma, but again, she's a catch, and the suitors will come calling, and I'm not so sure Wilma won't spend it all, and then there'll be nothing left for my kids. So Fred says, you know what? I'm gonna choose the other option. There is no right or wrong here. Both are very common, but Fred says in his mind, I want to make sure I provide for my wife Wilma if I pass away, but I also want to make sure that my children receive the inheritance from me after Wilma dies. So Fred says, I like this second option of leaving it in a trust. So Fred dies. Again, they had $4 million. Fred has $2 million. William has $2 million. Wilma has $2 million. Fred dies. Wilma still has her $2 million to do whatever she wants to with, which she could leave that to the children. She could leave it to her next spouse. She can do whatever she wants to with it. She can spend it all. It's her $2 million. But under the second option, as to Fred's $2 million, it's going to go into a trust when Fred dies. The trust is likely to say that Wilma gets the income from that trust, perhaps for the rest of Wilma's lifetime. More on that when I talk about the tax consequences later. And so if that $2 million, who knows what the $2 million asset-wise consists of, but if after Fred dies, Fred's $2 million goes into a trust, and maybe there's some cash, maybe there's some CDs, maybe there's some stock bonds, maybe there's some rental property. So Fred would likely say that when I pass away, my assets go into a trust. Wilma gets the income from that trust for the rest of her lifetime. So if that $2 million of assets, I'm not talking about capital appreciation at this point, but I'm talking about income, interest, dividends, rental income. Fred says, I'm going to leave my $2 million into a trust, and I'm going to allow Wilma to get the income from that trust for the rest of her lifetime. So that's where it starts. Fred in trust, Wilma gets the income for her lifetime. So Wilma has her own $2 million, and she gets the income off of Fred's $2 million. And then Fred's got more decisions to make if he goes down this path. So the decisions often are, well, should Wilma, in addition to getting the income that this trust generates, is she also going to be entitled to distributions of principal after I pass away from my $2 million? So yeah, if my $2 million consists of a $200,000 CD that's paying 2.5% interest, yes, as the income beneficiary, Wilma will get all of that interest, but can she dip into the principal? And so that's a decision Fred has to make, or Wilma. Fred and Wilma will often make these decisions together and do the same thing regardless of who dies first. But Fred will have a decision to make of, does he allow for any distributions of principal to Wilma after Fred dies in addition to the income? And typically when distributions are permitted, the trustee has the discretion to make distributions of principal to Wilma for her health, education, maintenance, and support, the typical HEMS, HEMS, standard health, education, maintenance, and support. And so if she is entitled to principal distributions, is she entitled to that for the rest of her life? Or is she entitled to no principal distributions? Or is she entitled to principal distributions until she remarries, and then her ability to get principal distributions stops at that time? So those are all decisions married people need to make if they're going to leave their estate in trust for their spouse. Again, the idea being, when Wilma dies, what's left out of Fred's portion, or what's left in the Fred trust, automatically reverts back to Fred's two children. Wilma does not have the ability to change who's going to get the Fred trust after Wilma dies. That was predetermined and locked in when Fred dies. So under this second scenario of Fred leaving his estate in trust for Wilma, providing that she gets the income from that trust for the rest of her life, perhaps even providing for principal distributions for health, education, maintenance, and support, and then providing that when Wilma later dies, the Fred trust goes to the two children. A couple of other real important points about that. One important point is who's going to be the trustee of that trust after Fred dies? Is it going to be Wilma? And maybe Fred likes the idea of naming Wilma as the trustee of the Fred trust after Fred dies first. Going back, Fred and Wilma, $4 million. Fred has $2 million. Wilma has $2 million. Fred dies. He doesn't just want to leave it all to Wilma because his kids may never see it. No offense to Wilma, but so he goes, I'm going to leave mine in trust for Wilma, and she'll get the income. Perhaps she'll be entitled to principal distributions when Wilma dies. Fred trust goes to the kids. Now, again, who's going to be the trustee? If Wilma is the trustee of the Fred trust when Fred dies, then she's got power. She's the trustee, and yes, she's going to get the income from the trust. And if the trust gives the trustee the discretion to make principal distributions to Wilma for her health, education, maintenance, and support, now Wilma has the ability to make distributions from the Fred trust to herself after Fred dies. And maybe Fred says, that's okay. I know she's going to do the right thing, but I also know that whatever is left in my Fred trust when Wilma dies is going to go back to my kids. But maybe Fred's saying, I don't even want Wilma to be influenced into taking too many distributions of principal from the Fred trust after Fred dies. So maybe Fred will say, boy, if I die first, I want Wilma and one or both of my adult kids to be co-trustees so that Wilma can't by herself take distributions out of the Fred trust after Fred dies and perhaps go do bad things with those distributions. I want one or more of my children or some other potential trustee or co-trustee to be involved in principal distributions from the Fred trust to Wilma. Okay, so who will be that trustee? It might be Wilma. It might be somebody else. It might be Wilma and somebody else. It might be a corporate trustee. You don't see that a lot, but occasionally. In fact, did it just yesterday where we have it set up so that when somebody dies, assets go into a trust. Vanguard has a trust company. They're going to be the trustee. It was the best solution given the options and given the circumstances. So sometimes a corporate trustee is designated as the trustee of one of these spousal trusts. So be aware not only can the trustee make distributions of principal is one of those decisions, but also who will be the trustee or co-trustee is an important decision for spouses to make when they decide how to leave things to their spouse. So far, we've talked about the two options. Fred leaves everything to Wilma, or Wilma leaves everything to Fred. Let's look at Wilma dying first. Wilma says, well, if I die first, I'll leave it all to Fred. And now Fred's got the $4 million. He goes and finds true love, and he winds up leaving the whole $4 million and whatever it may have grown to his next wife. Wilma's kids get nothing. So now maybe it will have worked out. Wilma left everything to Fred. Fred's not going to make a move that would adversely affect his children. So he does leave everything to the children when Fred passes away. Things worked out great. So the second option, going back to Wilma dying first, they have $4 million. Wilma has $2 million. Fred has $2 million. Wilma dies first. And look, they can do this either through their will or through their living trust. So if Wilma dies first, her will says, when I pass away, I leave my estate in trust. I name Fred or whoever as the trustee of that trust. The trustee is directed to make sure Fred gets all of the income from the Wilma trust for the rest of Fred's lifetime. Trust might say for the rest of Fred's lifetime, Fred or the trustee is authorized to make distributions of principal to Fred for his health, education, maintenance, and support. And when Fred later dies, the Wilma trust goes back to her two children. Everything works great. So that's the second option, leaving things in trust for the children. The third option, don't see this as much, but this is where maybe the couple feels like they have enough in resources to live out their lifetime. And the couple definitely feels like if one of them passes away, there's enough resources available for the surviving spouse to be able to live out the rest of their lifetime in comfort. So sometimes, married people with children, they have this dual agenda. I want to take care of my spouse, and I want to take care of my kids. Sometimes the allegiance is more to the spouse, and sometimes the allegiance is more to the kids. And there isn't a right or wrong here. And sometimes it's kind of even. Just I want to take care of everybody. But a third option that a married person could exercise is, in fact, we did this earlier today. Maybe Fred says, you know what? I've worked hard at that rock quarry for 40 years, and I know we've got enough money where if I were to pass away, Wilma's fairly frugal anyway. There's no way she would go through all of our money. So Fred says, you know what? I'm going to leave a portion of my estate directly to my kids. Even if I die first, if I die first, I want my kids to get something, and I want to acknowledge them. And if I pass away first, I want them to go ahead and get some of their inheritance. I don't want them to have to wait until both me and Wilma pass away, because they're going to need it perhaps in their 40s and 50s. And who knows, Wilma's probably going to live to 110, and I don't want our kids to have to wait until they're 80 to receive an inheritance. So maybe maybe Fred says, or Wilma might say it as well. Fred might say, you know what? Let me leave $1 million, or let me leave. Fred had $2 million. Maybe he'd say, let me leave $500,000 to each of my kids. Even if I die first, they'll get it right then. And then, or maybe Fred says, I'll leave 25% of my portion of everything to each of my kids, and I'll leave the other 50% of my portion to Wilma, either outright or in trust. And that way, under the $4 million married couple estate, Wilma will still have her $2 million, and in some form, she'll have $1 million of Fred's $2 million. So she'll have $3 million. And again, with Wilma being frugal, they feel like that's more than enough. Wilma's probably going to get Social Security. She's probably going to get Fred's pension from the rock quarry. So that's a third option. So let me just real quickly recap the three options. Then we're going to go into some special circumstances and some tax consequences. The three options, again, one of the most important decisions married people have is how to leave their estate to their spouse. Do you leave it outright to your spouse? Simple, easy. You want everything to go to your spouse. Your spouse is likely to preserve it, maybe even grow it, and then your spouse is likely to pass it on when your spouse passes away to the people that you'd want to get it anyway. And so the potential downside is if you leave everything to your spouse, then your spouse owns the entire shooting match, and either intentionally or unintentionally, your spouse could make a mistake, or your spouse could do something that would prevent your children from receiving a nickel of what you had. And that really sours things when that happens. So it's hard enough. Not that I do feel like, in this environment that we're in, where parents now who are in their 70s and 80s and 90s, they've probably saved their whole life, because they went through some really hard times when they were young, and they've saved and they've accumulated. And it seems like this generation of people who's in their 40s and 50s maybe didn't save as much, and we're in a more expensive world these days. And there's so many statistics on people in 40s and 50s not having enough for retirement. And so not that the children are entitled to the parents' money, and children ought to go out there and work for what they have, and save enough so that they have enough independent of a potential inheritance. But most parents would like to see what they have worked for and what they have saved go on down to the next generation, their children. They'd like to make the children's lives a little easier if they can. And so, and really, I think most children out there have some expectation, not that they should be dependent on it and not that they should rely on it, but most children who are in their 40s and 50s kind of have this expectation that, and may even make it part of their retirement planning process, that when the parents die, the assets are going to go down to the next generation or the children. And when it doesn't, oh, surprise, children didn't know that surviving spouse was going to do this. Problems happen. Okay. So next, what I want to do is go through the tax consequences of these various decisions. And to really magnify the tax consequences, let's bump up the numbers a little bit. Let's say Fred Flintstone was president of the rock quarry and wound up with he and Wilma had $10 million. Now, this is a discussion about how those options of leaving things to your spouse, how does that affect the overall tax situation of Fred and Wilma and the kids? So to really address the tax situation, we have to just lay out what the federal estate tax laws are. So when people die in 2024, every estate has this $13.61 million federal estate tax exclusion amount. For starters, that means when Fred dies, you add up everything that Fred owned, and if he had less than $13.61 million, there's none of this 40% estate tax. And if when Fred dies, Fred had more than $13.61 million, then a 40% federal estate tax applies. Although the way Fred may have set things up because he's married is he likely set things up so that no tax is due when Fred dies. Assets get shifted around into Wilma's estate under circumstances that we're about to talk about here in a minute. But let's just keep it really simple. People who die in 2024 have a $13.61 million exemption. Some married couples initially think, wow, we have $14 million. So if we die, there's going to be tax. But no, married couples, each spouse has their own $13.61 million estate tax exclusion amount. So really with married couples, $27.2 million they can have and leave to whoever without the 40% federal estate tax. Now, that estate tax exclusion amount, or maybe you call it an estate tax exemption of $13.61 million for people who die in 2024, it's going down. So, or it's scheduled to go down. If no tax laws change, then on January 1, 2026, the estate tax exclusion amount will be cut in half. We don't know what the number will be exactly because the number gets increased every year based on the inflation adjustment factors. But let's just say for fun, in 2026, when somebody dies, they'll have a $7 million exemption. Fred and Wilma don't plan on dying this year in 2024 or next year in 2025. They got a lot planned, and so they're going to make it at least to 2026 when the exemption is $7 million. So let's say they have $10 million. And now let's go back over the examples. And we talked about the non-tax considerations of leaving things outright to your spouse, leaving things in trust for your spouse, or not leaving anything for your spouse at all. Now let's talk about the tax consequences of that. Okay, so Fred and Wilma now have $10 million. Fred owns 5, Wilma owns 5. Fred says, I'm going to leave my estate outright to Wilma. So Fred has a $5 million estate. He dies. Let's say the exemption when Fred dies is $7 million. No problem. There's no federal estate tax due. Fred's gross estate is $5 million. The exemption is $7 million. There's no tax. However, Fred said, I'm going to leave everything to Wilma. So now Wilma has her own $5 million, and she also has what was Fred's $5 million. So now she's got $10 million, and she has a $7 million exemption also, but she has $10 million now because Fred left everything to her. So about a decade ago, Congress enacted some new tax laws that really solved a lot of estate tax problems for married couples, particularly when the first spouse died and did leave everything outright to their spouse. They created something called portability. So when Fred died, Fred had a $5 million estate, and he left it all to Wilma. When a person dies for federal estate tax purposes, and they do leave their estate outright to their surviving spouse, that bequest to their spouse qualifies for the federal estate tax marital deduction. So our estate tax laws say, yep, you add up the value of your estate, and if it's more than $7 million, you owe us tax. But then they say, however, if you leave anything to your spouse, that gets deducted from your gross estate before the net estate is calculated, because generally the estate tax laws are designed to force the big estate tax payment, not when the first spouse dies, but when the surviving spouse dies. So by Fred having a $5 million estate and leaving it directly to Wilma, Sure, he had a $5 million estate, but since he left it all to Wilma, his gross estate is $5 million, but his net estate is zero because he left everything to Wilma. But now the problem is Wilma has $10 million. And if she dies, she might get whacked with federal estate tax because she has more than the $7 million exemption that will be in 2026. So in order to avoid or minimize or perhaps even eliminate federal estate tax when Wilma later dies with a $10 million estate, when Fred died, even though a federal estate tax return was not required to be filed, and it's called IRS Form 706, a federal estate tax return is required to be filed if Fred's gross estate exceeded the appropriate exemption, but it didn't. He had $5 million, the exemption was $7 million. But his estate, or the executor of his estate, probably Wilma, she does the smart thing and she files a federal estate tax return, IRS Form 706, and makes the appropriate portability election because Fred's net estate was zero. He had $5 million, but he left it all to his spouse, qualifies for the marital deduction. His net estate is zero. He didn't use any of his $7 million exemption. So by filing the federal estate tax return and making that portability election, his estate tax exclusion amount is what's called portable. He didn't use it. He had a $7 million exemption. So by making the election, Wilma not only has her $7 million estate tax exclusion amount, but on top of that, she gets to use the $7 million estate tax exclusion amount of Fred that he didn't use. So now Wilma can have as much as $14 million if she dies in 2026 without having to incur any of the 40% federal estate tax. Again, the tax is based on the fair market value of what someone owns when someone dies. So it's really, it used to be a big no-no for estate tax purposes to leave everything to your spouse and lump everything into the surviving spouse's estate because it caused the surviving spouse's estate to be too large. But now with portability and the portability election, you can add the deceased spouse's exclusion amount to the surviving spouse's exclusion amount, and in this case, eliminate tax because it enabled Wilma to pass away with a $14 million estate, perhaps more. If the exemption when Wilma dies years later if her exemption is $11 million and she gets to add Fred's unused $7 million exemption to that, she'll be able to exempt $18 million from the federal estate tax. So that's the issue. That's the tax issue. That's one of the tax issues. That's the estate tax issue of leaving everything to your spouse. Never going to be any tax when the first spouse dies because of the marital deduction. But when the first spouse dies, if there's some wealth there in your family, you certainly want to take a look and see whether filing an estate tax return, even though it's not required, but filing it in order to make that portability election, whether that wouldn't make some sense. It makes a whole lot of sense in a lot of circumstances. Okay, another tax consequence of leaving everything to your spouse involves the capital gains tax. What we've been talking about for the last few minutes is really for wealthy people, people with 7 million, people with 13.61 million, married couples with 27.22 million, avoiding the 40% federal estate tax. What I'm going to talk about now really affects even middle-class people. I'm not saying even middle-class people to disparage them, but maybe I should have just said affects people with a fair market value of an estate that doesn't even approach the estate tax exclusion amount standards. Okay, so now let's go back down to the Fred and Wilma have $4 million. Each one has $2 million. They're thinking, we don't have to do anything. This estate tax will never hit us. We realize we could have 27.2 million this year, but even if we die at the wrong time, we could have as much as 14 million and still there'll be no federal estate tax. But we'll keep an eye on those laws because they can change. Now let's talk about the capital gains tax. So let's say Fred and Wilma, they're 4 million. It came as a result of some good investments. So Fred down at the rock quarry, he liked his technology. So years ago, he bought some Apple stock for $20 a share. And now it's worth, let's just call it $200 a share. So the basics of capital gains tax are if while Fred is alive, he sells that that Apple stock that he bought for $20 and is now worth $200 per share, there's $180 of capital gain, of which Fred will have to report and pay capital gains tax on that $180 of gain. That'll smack him pretty hard. But however, the basics of the step up in basis are if Fred dies and owning that Apple stock that he bought for $20, and when he dies, it's worth $200, then that stock gets a step up in basis. So the new basis when Fred dies is the value on the date that Fred dies. Let's say it's worth $200 when Fred dies, and whoever inherits that, Wilma, the kids, whoever, and trust for Wilma, whatever, wherever it goes, the new basis of that stock will be $200. So if it's sold after Fred dies for $200 per share, even though he bought it for $20 a share, there's no capital gains tax to report, no capital gains tax to pay because of this really generous and one of the few tax breaks that we have, especially from an inheritance standpoint. It's kind of a big deal, especially if an older person owns appreciated assets. So here's the deal. Fred leaves ownership of everything to Wilma. How does that affect all this capital gain stuff? So when Fred dies, depending upon what state Fred lives in, if he lives in a community property state, and Fred and Wilma own community property together, which most people in community property states do, then when Fred dies first, believe it or not, some people kind of ask me again on this one, but when Fred dies living in a community property state, and he and Wilma had community property, all of the community property, not just Fred's half, all of Fred and Wilma's community property gets a step up in basis when the first spouse dies. And so that's a great thing. There's nothing wrong with that. Hope it stays forever. And that's a real benefit when the first spouse dies, step up in basis. So that rule often encourages people to hold on to appreciated assets rather than sell them while they're alive, because they want to take advantage or want to enable their survivors to take advantage of the step up in basis. But we gotta keep going. So Fred left everything to Wilma. So all the community property got to step up in basis when Fred died, but Wilma may live another 20 years. But Fred left his estate to Wilma. Now all of the assets are owned by Wilma, all of the $4 million. She lives another 20 years. Maybe it grows to $10 million from the date Fred died until 20 years later when Wilma died. Well, because Fred left everything to Wilma and he put it all in her estate, which was okay from an estate tax perspective and portability and all that, because Wilma owned it all and it grew to 10 million, then because Wilma owned it all of it gets another step up in basis when Wilma later dies. So all that stock, Fred bought it for $20. When Fred died, it was worth $200 a share. When Wilma died later, it was worth $1,000 a share. So now when Wilma dies, because Fred left all of his half to Wilma and she owned it all, and everything that Wilma owns when Wilma dies gets a step up in basis, Fred and Wilma's two children are coming out smelling like a rose. So they can sell all that Apple stock. If it was worth $1,000 a share when Wilma died, they only pay capital gains tax on what they receive in excess of that $1,000 a share. And so that's a pretty good deal. So really the tax, kind of the tax smart move, and we never do want to make moves, estate moves or life moves solely as a result of tax consequences. But this leaving everything to the spouse, lumping everything into the surviving spouse's estate, letting it all appreciate in the surviving spouse's estate so that all of it gets a step up in basis when the surviving spouse dies, that's a pretty good deal for tax consequences. Now, the non-tax consequences, Wilma could leave that $10 million to the postman, and that wouldn't be too good. But it'll be good for the postman because he'll get a step up in basis and he can sell everything for $10 million and pay no tax. Okay, so that's the tax consequences on leaving everything outright to your spouse. Now let's look at Fred liked the second option because he wanted more protection for his kids. Fred left his $2 million estate in trust for Wilma, but with the kids to get it when Wilma dies. Now, generally speaking, I'm trying to keep things simple, is Fred died with his $2 million estate. Wilma had her own $2 million estate. if they lived in a community property state, when Fred died, all the community property would get a step up in basis. But if they didn't live in a community property state, then only Fred's part would get that step up in basis. And so Fred leaves his estate, and again, Fred dies. The Apple stock is worth $200 a share. Fred leaves his part of that in a trust for Wilma. Now Fred's $2 million technically is included in his estate. That $2 million is not lumped into Wilma's estate. And so Wilma doesn't own Fred's $2 million when Wilma dies. She only owns her $2 million and whatever it may have appreciated to, if it appreciated at all. And so only Wilma's $2 million, or whatever it grew to, maybe it grew to $5 million, only Wilma's part gets that step up in basis when Wilma later dies, because Wilma didn't own Fred's part that was left to a trust. So Fred's part would get the step up in basis when he died, but if Wilma lived another 20 years, Fred's part is not going to get another step up in basis. Still, federal estate tax was avoided. Still, there was a step up of Fred's part when he died. Still, there was another step up of Wilma's part when she later died. But there's not going to be what I call that double step up of everything when the surviving spouse dies. So be aware there's some capital gains tax consequences. A lot of married couples will, as they, I can see them, kind of going through their head. Do I leave the things outright to my spouse? Do I leave things in trust for my spouse? And then they learn about this. They're really kind of perplexed because they feel like their spouse is going to do the right thing, whether it's left outright to the spouse or in trust for the spouse. And then when they find out that everything's going to get this double step up in basis, if they leave everything outright to their spouse, it'll all get a step up in basis when the surviving spouse dies. They're like, yeah, let's do it that way. And, that way my spouse will do the right thing with the assets, and my kids will benefit from the step up in basis of everything when my spouse later passes away. Okay, so now one more tax consequence of leaving things in trust for your spouse. Got to bump up the numbers a little bit. And let's say when Fred dies, the exclusion amount is $7 million. But when Fred dies, he has his own estate is worth $12 million, regardless of what Wilma has. And so if he left his estate to Wilma, no estate tax, great, unlimited marital deduction. She's going to have a really large estate, and some portability is going to be elected when Fred dies on his estate tax return. But even if Fred has a $12 million estate and the exemption is $7 million, if Fred dies and leaves it all to Wilma, no federal estate tax when Fred dies. And so now let's look at the Fred leaves his estate in trust for Wilma option. It's $12 million. But Fred wants to make darn sure that when Wilma later dies, those $12 million or what's left of them goes back to Fred's kids. Now Fred dies, and we don't have the automatic unlimited marital deduction that applied when Fred died and left everything to Wilma. He left it in trust for Wilma. But, and here's where I'm going to get a little bit technical, he left it in what's called a Q-tip trust, qualified terminable interest property. Forget about it. Don't try to worry about what the words mean. But if Fred left his estate in a trust and stated in that trust that Wilma gets the income from that trust for the rest of her lifetime, it can't terminate upon her remarriage. She has to be entitled to the income for the rest of her lifetime. Then when Fred dies with a $12 million estate and a $7 million exemption amount, he's $5 million over the limit, then an estate tax return can be filed when Fred dies, because this leaving things to a Q-tip trust qualifies for the marital deduction, but an election has to be made on Fred's estate tax return, and that election will be something like this. Here's the assets on Fred's estate tax return, $12 million, exemption amount, $7 million. Fred's going to use his $7 million exemption to shield the first $7 million from federal estate tax. The other $5 million, again, it's all in the Q-tip trust, but there's an election made so that excess $5 million from an accounting standpoint gets no taxes paid on it, but that excess $5 million gets added to Wilma's estate from an accounting standpoint so that it's part of her estate when she dies in the future. Again, all of this is about at least Congress, if for the large estates, they do allow couples to arrange things so that if there's going to be tax due, even if it's after using both exemptions, the tax doesn't have to be paid until after the surviving spouse dies, or 9 months after the surviving spouse dies. So if here's my final say on married couples leaving their estate in trust for their spouse. If the first spouse to die's estate, if the value of that is not as much as the estate tax exclusion amount, a portability election on an estate tax return is going to increase the exemption amount of the surviving spouse. On the other hand, if the first spouse to die has an estate that exceeds the estate tax exclusion amount, Fred had 12 million, the exclusion amount was 7. Now the Q-tip election must be made on Fred's estate tax return to defer or to take those excess $5 million and not pay tax on them when Fred dies, but put them into Wilma's estate for possible estate tax payment when Wilma later dies. There's a mouthful there, but that's why they have people like me. Okay. So let me touch on a couple of special circumstances. Got a few more things to go, some important things to go, and then we'll head on over to the chat. All right. There are some circumstances where it makes sense for the first spouse to leave their assets to the surviving spouse. I'm gonna pick on the traditional IRA a little bit. So, and quite frankly, this is how most people do it because it's easy and it's simple. Husband and wife, they each have their own IRA. Whenever the husband set up his IRA account, it might have been 2 years ago. He might have retired and rolled over his 401k, maybe 3 years ago, 10 years ago, may have set up his IRA 20 years ago. It doesn't matter. But when he set up his IRA, he was asked to name beneficiaries. Who's going to get his IRA when he dies? And most people don't even think about all the stuff we've been talking about for the last 45 minutes or 50 minutes. And he just says, well, I'm going to name my spouse as my primary beneficiary and name my kids as my contingent beneficiaries. And then he starts learning about all these options and he's thinking, well, maybe I should leave my IRA to a trust for my spouse so that when my spouse later dies, at least those assets, and that the IRA may be his biggest asset, he may leave that. He's thinking maybe he should leave that to a trust. Wilma can get some benefits from that for her lifetime. And then when Wilma dies, those assets revert back to Fred's children. Sounds all fine and dandy. But when you have an IRA and you leave it to a trust, it complicates things because not only are the estate tax consequences involved, but now you got a bunch of income tax consequences and a lot of required minimum distribution rules on inherited IRAs. So all these income tax rules that apply to traditional IRAs after the IRA owner dies, we don't have that when we're dealing with a large bank account or a large brokerage account that gets a step up in basis when somebody dies, or a house or a business. But when you leave a traditional IRA to someone, whether it's to someone or to a trust, there's going to be some hefty income tax consequences that are really impossible to get around unless you leave it to a charity. So some of the concerns about leaving an IRA to a trust for your spouse is after you die and it goes into a trust for your spouse is going to need to take required distributions from that IRA. And those required distributions, if your spouse lives long enough, will deplete that IRA so that when your spouse later dies, there's nothing left to give back to your children. So some people who really kind of educate themselves on all of this, they'll say, yeah, I have a large IRA. And I know it will be complicated if I leave my IRA to a trust. So Fred might say, my IRA is worth $1 million. I'm going to go ahead and leave 25% of my IRA directly to my children if I die, and I'm going to leave Wilma 50% of my IRA. So especially if Fred's 2 children were children from a previous marriage, and he really is concerned that if he left his IRA to Wilma, that his kids would never see any of it. So it is not common, but it is advisable for married people, if they have a large IRA, to consider leaving a portion of it to their children and a portion of it to their surviving spouse, particularly if the IRA owner's children are different from the spouse's children. So be aware, IRA, a lot of complex income tax rules. So maybe avoiding leaving that IRA to a trust may work out better in the overall scheme of things. All right, here's another unique circumstance, but a lot of families get bit. This is clearly a middle class issue here. If you're tired of hearing me talk about the $4 million estate, the $10 million estate, the $27 million estate, listen up. So this is a potential Medicaid eligibility scenario. So let's say mom and dad, Fred and Wilma, let's say they have an estate of $600,000. Each one owns $300,000. They're old, they're 75 years old, they're 80 years old. They're trying to figure out how to leave things to each other and leave things to the kids. Of course, they're thinking, if it's Fred and Wilma, and now Fred and Wilma are 80, they're thinking Fred's going to say, geez and Pete's, yeah, of course I want to leave everything to Wilma. And then Wilma will leave it to the kids. She's 80. Who's going to want to marry her? And he's probably right. So now, but that's the old, I love you, Will. I leave everything to my spouse. However, if Fred dies and then if Wilma, because Fred's been taking care of Wilma, she's not doing too well. She broke her hip. If Fred dies and Wilma has to go into a nursing home and Fred left, remember they had $600,000, each one had $300,000. If Fred left his estate, his $300,000 to Wilma, now Wilma has the entire $600,000. And she's going to have to spend every last nickel of it until she has less than $2,000 in her name before she would be eligible for Medicaid if she had to go into a nursing home, which she will because she broke her hip and Fred's not around anymore to take care of her. So these situations where people are older and they're trying to figure out how to leave things to the spouse, how to leave things to the children, Fred might say, you know what, I'm going to leave my part. I just had a heart attack and what I'm going to do, Fred says, is I'm going to leave my $300,000. I know we have $600,000. Fred has 300. Wilma has 300. Fred says, I'm going to leave my 300,000, not to Wilma, but I'm going to leave it to the kids. And then the kids, when Fred dies, they'll just set that aside because they know it's really to provide for Wilma's needs. But now if Wilma needs to go into the nursing home, she only has to spend her $300,000 of the assets before she qualifies for Medicaid, long-term care Medicaid eligibility. She won't have to spend Fred's $300,000 because he left it to the kids when he died. No 5-year look back or anything like that because Fred died. He didn't give it away. He died and left it to the kids as an inheritance. So that little maneuver there just saved the family $300,000. In fact, if you want to take it a step further, let's say Fred is he's no longer taking care of Wilma. Wilma has a broken hip and she's going to live for a while, but she may need to live in a nursing home. And I'm going to be kind of this is going to sound cold because it is, but people like to hear the blunt version versus the sugar-coated version. Let's say Fred's about to die, and we never know for sure, but doctors are saying he's going to die any day now, or any week now, or maybe in the next month or two. That family may decide to load up the assets on Fred's side. He owns the $600,000. Wilma has nothing, or she has little. Let's say they changed it so Wilma donated some of her part to Fred. Now Fred has $500,000. Wilma has $100,000. Fred dies. He leaves his part to the kids. Kids get the $500,000. They set aside. They know it's for Wilma. Wilma now only has $100,000, and she's only got to deplete that before long-term care Medicaid eligibility would kick in. Yes, and in all of those scenarios, there were no gifts or no uncompensated transfers that would have triggered the 5-year look-back period. This is just what happened when people died. Transfers among spouses are exempt from this 5-year look-back period. So Wilma could dump things into Fred's estate and then have Fred leave all of that to the children. So be careful on some of these potential Medicaid eligibility consequences that married couples face when they leave things to each other, perhaps the wrong way. All right, so let me sum this up, and then we're going to hit the chat. I see there's some activity over there, and I'm seeing some names that are familiar, so I'm looking forward to chatting with you guys. All right, so sum it up. This how as so many estate planning decisions to be made, this decision of if you're married, how you're leaving things to a spouse, and it's usually set up where the married couples go through this exercise together, and 90+% of the time, the each of the married spouses chooses to do the same thing for their spouse. So it's reciprocal. What one does, the other does. But I've seen circumstances where husband says, "I'm gonna leave it all to my wife," and wife says, "Nope, I'm not gonna leave it all to my husband because whatever. I'm gonna leave it in trust for my husband." So couples can do it that way, but that's uncommon. All right, and so you have this decision. Do you leave it outright to your spouse? Do you leave it in trust for your spouse? Do you not include your spouse as to some or all of the assets? Leave it directly to the children, the heirs, or the other beneficiaries, and know that all of these decisions have tax consequences, not just the estate tax consequences that the wealthy face, but the capital gains tax consequences that virtually everyone faces, and even income tax consequences, particularly as it relates to distributions from traditional IRAs. Okay, so with that in mind, it's time for some chat. So let's see what we've got here. Always want to say hello to Larry. He's the MVP, and Anne is approaching Larry's status. So good to see you guys here. Let's get to some questions. Hey, Sherry. Hey, Michael. We got Seattle. We got West Virginia. Maria, you look familiar. In many other countries, children also have a property right and get a share. Yep, there is not only in countries, but I'm gonna leave it at that. There's a little bit of that stuff in some states here, but in general, married people have the flexibility if they want to not be forced to leave something to the children. Anne likes blunt pebbles and Bam Bam. Oh, hey, there we go, Michael. Good Pebbles. We got Pebbles, John True. Those guys at the bingo hall, or first option, but can't. Oh, and so really, before I get into the questions, let me pose a little challenge in your chat. At the very end of the chat, y'all can all answer this question. And so let's say this happens to you. Let's say your friend who's 55 years old comes to you tomorrow and says, "Anne, I value your judgment. Anne, I know you're really smart, especially about this financial and estate stuff, because I know you've been binge watching Paul Rabolet's videos." And your friend says, "I just haven't had time to do it, but I need your advice, Anne. Here's the deal." Your friend says, "I'm married. I have a $2 million estate. And look, my spouse and I," your friend says, "we have a great marriage. We've been married for 25 years. We've got 3 good kids. But, Anne, I need your advice. I just don't know what to do. My lawyer's telling me I've got a couple of options. My lawyer's telling me, Anne, I could leave my $2 million just directly to my spouse. I don't have any problem with that, Anne. I trust my spouse. But I still know that things happen after I pass away. If I leave my $2 million outright to my spouse, who knows what might happen. And my spouse is attractive and good looking and cooks and is going to have some money. And so people may prey on my spouse if I leave my $2 million to my spouse. I want to leave it to my spouse because I trust my spouse. And so, I just don't know if that's the right thing to do, because I've got this other option, where I could leave my $2 million in a trust. And I don't want to make it look like I don't trust my spouse, but I'd like to protect my children. I'd like to make sure they inherit from me one day. I don't want to leave them assets directly when I pass away. But my other option, Anne, is I could leave my $2 million in a trust for my spouse. And then my spouse doesn't own it, and my spouse can't do whatever they want to with it. But when my spouse dies, what's left in those trust assets will go back to my children. And you're the guru. You've been watching this Rabelais guy for every night. You've been telling me, what should I do? Okay, so you need to tell your friend who has a spouse, loves their spouse, but also has children that they love. You need to tell them what to do. Do you tell them to leave it outright to their spouse, or do you tell them to leave it in trust for their spouse, or do you have more conversation because it depends? Love to see your answer in the chat below. Not just Ann, but everybody else as well. Okay, so we've got, can we just put a protective provision stating that the portion of the first spouse belongs to the children? Well, leaving it in trust, I'm not picking on you, SW, but we have to follow the rules. And sometimes you can't just put a provision. The protective provision is putting it in a trust. So I had someone yesterday try to draft an amendment to their trust. And I'm like, what are you doing? 99% of what you just wrote when you tried to make an amendment to your trust isn't even permitted under the state trust code. What are you doing? So no, you have to follow the rules. Otherwise, all heck breaks loose, because if somebody gets a chance to question something because of ambiguity, or maybe it wasn't clear or wasn't black and white, then you got big problems. So I don't know if this is what you're getting at, but you can't just say something like, I'm leaving it to my spouse, but hey, spouse, make sure you leave it back to my kids. In fact, that's you can't do that under our estate laws. You can't say, I'm leaving my estate to my wife and I'm directing that my wife later leave it to my kids. So you have to leave it in trust for them. So anyway, that's my best answer to your protective provision question. And I remember back then people didn't want to print obituary books because people would come knocking on the door. Yeah. So that goes back to the privacy stuff. And I'm sure that still exists. Man, I'm giving William the side eye. John, good, whatever that means. Wilma, maybe? I don't know. Michael, how does the strategy change if a large part of Fred and Wilma's assets are in retirement savings, possibly when Fred has much more than Wilma? Yeah, similar issues. So Fred and Wilma have $4 million together, but $3 million of it is in Fred's IRA. He worked at the company for many, many years, built up his 401k, saved everything he could, retired, rolled it over to his IRA. So now the big question is, what happens to Fred's IRA when Fred dies? Yeah, if Wilma dies first, Fred's still going to have his $3 million IRA. But if Fred dies first, so there's Wilma's options are limited because she doesn't own the $3 million IRA. It's in Fred's name only. An IRA has to be in only one person's name. Wilma may own half of the other assets. So the amount that she can protect is limited. But if Fred dies first, maybe he leaves a portion of that $3 million IRA to Wilma, leaves a portion to the kids. So I'd say lesser options when the bulk of the assets are in an IRA. And of course, that IRA is going to be only in the name of one spouse. Good question. All right, Johanna, can you leave an IRA to a trust and then have distributions given to the surviving spouse after their death that would go to the kids? So can you and should you are two different questions. Can you? You absolutely can. But should you? Maybe. But if you leave your IRA to a trust for your spouse, required distributions must be taken. That principal can't just sit there until your spouse later dies. And my point was those required distributions that must be payable to your surviving spouse out of that trust after you pass away. If your spouse lives on long enough, they may deplete the trust. They may have taken everything out of that trust through the required distributions. And then once they take it out of that trust because they're required to, they can leave it to whoever they want. So those are some of the potential problems of leaving an IRA to a trust. The other potential problem of leaving an IRA to a trust, I hate to say it, but it's reality. It just confuses the heck out of everybody. It confuses the spouse. It confuses the kids. It confuses the accountants. It confuses the attorneys. It confuses the financial institutions. Anybody related to it is like, oh, what are the rules now? We don't understand it. They are complex. They're difficult to understand. And so that's just a little bit of a nuisance factor, not that you can't get around it. All right. Love the Flintstone references. Yeah, I'd come home every day from school, watch the Flintstones. Those used to crack me up. That's what we did. Went ahead and gave very good. Okay, that's what we did. Went ahead and gave the inheritance to the children. Could be done during your lifetime. Could be done when you pass away. John Smith, 40% yikes. It is a yikes. Make sure your executor is a CPA. I wouldn't say that's a hard and fast rule by any stretch. Maria, 28. I like your advice. So I would say the customary thing to do is not that the customary way is right, but the customary as far as who should be your executor, typical is a family member. Now, that family member can get help from a CPA, from a lawyer, or any other professional advisor that they may need. So it's customary to name a spouse if you're married, maybe adult child who's responsible if you have children as perhaps the backup to your spouse. CPAs really aren't in the business of being an executor. CPAs are in the business of accounting work. And just like lawyers are in the business of providing legal services. Lawyers aren't in the business of being an executor. Yes, do I understand what an executor's role is? No doubt about it. But if Fred Flintstone dies, and maybe I drafted his will or trust, but and I might not even know his kids, and I've never been to his house before, and I don't know what kinds of personal effects he has, and so I'm the guy who's going to go in and deal with the house and putting it up for sale and deal with all the belongings in the house. Sometimes it doesn't make sense for the attorney or the CPA to be the executor. Again, it could be, but often a family member who gets good professional help from CPAs, attorneys, and perhaps even others. What is your thought on bank accounts? I have no idea what you're asking me there, Suma Holmes. Let's see here. Gosh, every time I scroll, I lose. All right. Let me keep going. Okay, I'm back. I found it. Can Wilma change trust info? Well, that's the good question. If Fred left his things outright to Wilma, she can change who gets the whole shooting match. If Fred left his part in trust for Wilma, Wilma can only change where her part goes. That's an underwriting. Oh, you need to understand that. So hope you do. Learning here, thanks. Also, Fly Girl, good. Excellent presentation, very complicated subject, tax implications. It is. Newell, thank you for your comments. And that just, thank goodness, I've been doing this for 30 years. Used to be 3 years. Look back, it did used to be 3 years. Before that, it was 2.5 years. And before that, it was 2 years. So Austin's in the house. Austin, I was thinking you were Australia, Fly Girl. Now you're Austin. Very good. Okay. Missouri here. John, good to see you from Hawaii. I'm a drunken married man. I'm a drunken, try to travel. I'm a drunkard married man. Can my wife use that in my divorce to take my assets? I only have 1 DUI and 2 felonies. I don't know. I don't know. Larry, LD, now it's taken me only about 30 of these live streams so that when I see LD, I know it's Larry. Thank you for your time. You covered a few things I had not considered. Good. Fantastic. By the way, no more live streams are scheduled on the books. I will do more. You'll just have to check the channel in the live tab. I just haven't scheduled them. Is this for spouse? Leave the money to children or leave the money in trust for spouse? Trust, irrevocable trust, more conversation. It depends. Okay. Now we're down to you answering the hypothetical. Your friend asked you what to do. And yes, when Fred does leave his $2 million estate in trust for Wilma, then when Fred dies, that part of the trust or his part of the trust becomes irrevocable. Nobody can change the terms of that Fred trust after Fred dies. Need more discussion. And so that's the right answer. You need more discussion. Don't know exactly what the state is comprised of, money, IRA, house, so it really does depend. That's the right answer, Larry. It does depend. Schedule a call with Paul. So yes, this live stream is not a plug for my services, but if you'd like to chat, maybe start the process, maybe even have us help you, links in the description for you to get that process started. Shane, split up the money and set up a trust for your kids, a separate trust for your husband, a separate trust for any grandchildren. Sure. Fantastic answer. Help everybody. That's kind of spreading the risk there. Can Wilma change trust info? What do you mean trust info? I'd leave the $2 million to the spouse. Can't argue with you there, Nelbo. Saw you here last night and even before. Sounds like you got a great marriage. That's just what it sounds like when you say I'd leave it all to my spouse. So good for you. Protective provision sounds like great movie from the early 80s involved in this. Body heat is thanks. Good to know. My friend said her trust is still revocable after the first spouse dies, but they can't change the beneficiaries anymore. So from your answer, it seems that doesn't make sense. So doesn't make sense that one person would die, leave their assets for the surviving spouse, and it's all in a revocable trust. But the surviving spouse can't change who gets it. That's conflicting information. Something's out of whack there. By the way, I'm a longtime subscriber, but first time participating. Thank you very much. SW, love having you here. If I give my children $100,000 each year filling out a 709, can Medicaid still use the 5-year rule? Yes. What you do from a gifting perspective, from a tax perspective, some people say, well, can I give my child $18,000 a year? And that's just off the books. That doesn't even matter. In your case, you're saying, can I give my children $100,000 a year, report it that I've used my exclusion amount on a gift tax return? Medicaid could care diddly squat what you did from a gift tax perspective. If you made a transfer of assets to someone else, if you made an uncompensated transfer, $100, $1,000, $18,000, $36,000, $100,000, the gift tax limits are completely irrelevant for purposes of you making uncompensated transfers that would render you ineligible for long-term care Medicaid. Excellent question there. Glenn Natat, or the way or whatever. Bobby, when my husband and I pass away, how do our executors sell our home? What is procedure? House is in trust. So a little bit of conflicting information. It's just lingo, Bobby. So if your house is in your trust, then in your trust, you designated who are your successor trustees. You're the initial trustees, but you designated successor trustees, which is when you die, who handles the trust. That successor trustee can sell your house the day after you pass away. Let's say they sell your house for $500,000. That trustee goes to the closing, gets a check payable to your trust for $500,000. Your trustee goes and deposits that money in a trust account that may already exist or one that they set up at that time. And then if your trust is a typical trust, then whoever that successor trustee is will then disperse the trust assets, including the proceeds of that sale, to the trust beneficiaries. Hope that helps. Let me know. Thanks much. Under Summa, make sure the notification on, like, subscribe, all that stuff. We want to get those numbers up. Austin 7117, hit that like button. Can you think of anything? Loving Austin Fly Girl right now. Trying to be as helpful as I can. If we're going to sit here and chat and go back and forth on an hour, we might as well be productive. So that's what I'm thinking. I will tell my friend to set up a trust, but further discussions with a lawyer are certainly needed. Excellent answer there, SW. Austin, hey, there are single people with no spouse, no children. We need a chapter on the list. King Otis, saw you last night. Have you ever heard of a bank not needing to see any part of the living trust open a trust bank account? Some banks will rely, they'll at least require a trust certificate or an extract of trust, or it could be called something else. So oftentimes banks don't need to see the entire trust instrument. They need to see this summary of a trust or certificate of trust that is signed off on, that says, what's the name of the trust? Who are the trustees of the trust? So that certificate of trust tells the bank who is authorized to transact on behalf of the trust. So many banks say, yeah, we need the trust certificate before we'll enable a trust to open an account. So yes, it is possible that they don't need the entire trust. In fact, I spent today reviewing a 150-page trust that was done many, many years ago. And boy, I'd hate to see having to kind of submit that to a bank and have them sort through all of that. It was enough for me to sort through. Okay, so wraps it up here. And then what we're going to do from here, we don't have any more scheduled. This time slot works well for my schedule. So just if you want to periodically check the YouTube channel, check the live tab, and you'll see any upcoming scheduled live streams. Love to see you all back on here. Y'all have a great night. Stay warm. It's cold across America. We'll see you later. Good night.